Welcome, everyone. It's wonderful to be with you again for the third workshop in our six-part Let's Get It Done webinar series on estate planning. I'm John Mitchell, CEO of Ardenwood here in San Francisco. Actually, we're appearing live from Belvedere, Tiburon, if you know, right across the Golden Gate Bridge. And so right behind me is beautiful, magnificent Belvedere. And you'll see as the sun shifts to it gets light, it gets dark earlier as the light fades, you'll see San Francisco appear. It's pretty neat behind me. So right here in Belvedere. So we're here in Belvedere, and I'm joined by Rick Bailey, one of the most respected estate planners in the country. If you're joining us for the first time, welcome. And if you've been with us for sessions 1 and 2, thank you for continuing the journey. We hope this series is giving you both clarity and confidence as you move forward. And as always, we appreciate any and all feedback. Rick has helped countless Christian Scientists navigate the estate planning process, regardless of their circumstances or financial situation. We're truly grateful for his expertise and willingness to guide us through these practical sessions. So here's how today will flow. Rick will begin by sharing a few key insights, and then we'll open the floor to your questions and discussion. Our hope is that by the end of this series, you'll feel ready and equipped to meet with your attorney and finalize your estate plan. Now, to honor everyone's privacy, please submit your questions using the Q&A icon at the bottom of your Zoom screen. I'll read each question aloud anonymously. And just a brief but important reminder, these webinars are for general educational purposes only. You will still need to review and finalize your plan with your own legal counsel. And with that, Rick, the floor is yours.
Thank you. I appreciate it. It's great to be back. And today I want to take us a little bit a different turn on the planning. You know, most of the time when people think estate planning, they jump to end of life. They jump to, okay, how do I pass this on to the kids or the grandkids? And that's a big part of it. But I also want to talk about how do we get there from today all the way until we do pass away. And it's making sure we take care of you and take care of your family today, and that we don't just focus so much on the future that we forget what we need to do to get there. And I was telling John a little bit earlier, I have the perfect example was referred into me about a week ago. This is somebody that had done a lot of planning. They had planned on the husband would pass first. So all the planning was designed for him to pass first, and everything was basically put in the wife's name and done through irrevocable trust. And when we talk about trust, remember there's revocable trust. You can change that. So it's a revocable living trust. That's the foundation of your plan. Well, they had gone beyond that and had done irrevocable trust planning, put a bunch of their retirement assets into that irrevocable trust. And the wife had access to that money during her life. And then when she passes, it goes to the kids. They're planning. She passed early and she's young, and she passed. And now all of that money has been locked away. And they're coming to me saying, what can we do? And right now, I can tell you it's not going to be a good result. It's going to be a result. It's not going to be the result they planned on. And half of his retirement assets are probably locked away from him. So when you get into planning, the reason that we want to look at this, we don't want to put all our eggs in one basket. We don't want to just plan for the sake of planning. We want to make sure that we think through the process. You're different than John. John's different than me. We want to make sure that as we do this planning, it fits you and your lifestyle, your family, and we stress test that. We look at it, what if? What if one spouse passes away? What if the other spouse passes away? What happens if one of our kids passes away? We don't like to think about those things, but we need to. And so as we start talking about planning, we want to look at planning as a continuum, today all the way through until the end. The other part that we want to look at is, what do we have to plan for? We've got to look at your retirement. And for a lot of my clients, we're talking pre-retirement. So I work with a lot of business owners. We can't just ignore that and jump to the retirement phase or jump to the transfer phase. We've got to talk about, okay, what are we doing with your business today? What are we doing in retirement? What are we doing for long-term care? So your homework today was to go through some of those long-term care questions. And the reason that we look at long-term care is something most all of us are going to have to face. How are we going to allocate our resources in retirement in those golden years if we have to cover those long-term care expenses? So it's a big drain. And I'll tell you, the one that I look at, I'll throw myself under the bus here. Most men say, if we're married, well, my wife will take care of me. I don't have to plan because my wife will take care of me. And let's be honest, that's part of that is true. If something happens, our spouses are there to take care of us and help and do whatever. What happens in a lot of cases is, can our spouse take care of us? Are they healthy enough? Are they in a position to help? Are the kids in a position to help? And if not, do we have the resources allocated the right way? And so when we start looking at this, and part of that questionnaire is to get you thinking, because remember, if you do a trust and if you can't control your affairs, you're at the point where somebody else to step in for you. Have you set things up so they're taking care of you the way that you would like? Do you have a health directive in place to say, this is how I want to be taken care of? That's part of it. The next one is, have you set your finances up in a way that makes sure you can be taken care of the way you want to? And I'm facing this right now. My parents are elderly. It's at a point they want to stay in their home. And they're to a point now we have to go in. We're renovating part of their home now while they're living there, because they won't move out. And we're adding, an accessible bathroom. We're adding railings. We're adding ramps. All of those things will help them that, frankly, they didn't plan for. Even though I'm in this business, I have a brother that's in this similar type of business. We have talked to our parents about this planning, and they didn't think they needed to. But they live on a farm. It's an old farmhouse. And now we have to renovate that house while they're there to make sure that they can continue to live there like they want to. We could have done it 10 years, 20 years ago and been just fine with their help. And so you have to start looking at planning ahead, but making sure you're planning it the way that you want to take care of you. And the reason we've talked about getting our fiduciaries in place, the trustees, our powers of attorney, the agents for those, and making sure they know how you want to be taken care of, where you want to be taken care of, and then that the assets align so that can happen. So it's a process. And going through this process, we don't want to jump to the end. We want to take every step as we go.
And I think just to jump in, Rick, I think that's why we're doing these webinars, is because that's why you engage a professional. This is by the experience that you've just outlined, is why we're doing this with you and someone who really works with this, not a general practitioner in terms of being an attorney or whatever, but someone who's seen some of these movies before and says, no, we need to think of all these different scenarios. So thank you.
Yeah, no, it really comes back to, nobody's going to be the same, and everybody's going to have their opinion on how do they want to be taken care of, what matters to them. And I've had clients in the past that have moved into assisted living care that they were perfectly healthy. And I asked them, well, what, is there something I don't know? And they said, yeah, all of our friends are there. So we're going to move in. So we're next to our friends. Now that's rare. Most of the time it's people that, need the care. And so they're moving on to those areas that they can be helped. But it's the planning. The planning has to take place. And as you think about how you want to be taken care of, whether it's health, whether it's people managing your assets and managing your finances, put the people in place that understand how you want to be taken care of, and then we take those steps to make sure everything starts matching up. And that's the total plan. And as you go through life, things are going to change. We want to make sure we have as much of your plan that can be amended, reviewed and amended to make sure it keeps up with what your changing outlook on life is, your changing perspectives, whatever it is. Don't be like this new client of mine that, we're at that stage where, and I'll tell you this, he just turned 65 and just realized at the point he's ready to retire, half his retirement assets are locked away. Is that going to change his outlook? Yeah. Is it going to change his retirement? Absolutely. Because the finances he thought were there are not there anymore. And, I hate to say it, I haven't dug into it enough, but he might be at the mercy of his kids. His kids may have to start supporting them because they did some planning that didn't make sense. Maybe at the time, but not now. So we've got to look at all those different things and plan accordingly. Now, as you start thinking through this, when you're looking at your planning, and we've talked about this before, and we'll talk more about this over the next few sessions too. There's all of these planning tools are just tools. Now, there's reasons that we do this. And let's not let fear be a driving factor here. Fear is a motivator, but a lot of times fear can be a poor motivator. When you're doing your planning, we want to make sure that we're planning in a way that creates the right mood. I don't know if that's the right word, but that's the one that comes to mind. If we're scared of the planning or we're scared of the result, we need to back up and say, okay, what's causing this? Because the plan should create peace of mind. So as you start looking at your plan, we're looking at retirement. Let's talk through the retirement part of this. When we're looking at retirement, and I see a lot of financial advisors, they're doing a good job helping you think about this, climb the mountain to retirement. And as you're climbing that mountain to retirement, it's putting away money in your 401k or your IRAs or whatever your investments are. And everybody's going to be a little unique there. Well, they build. Now, if you think about retirement, we're now going to start going down the hill. And I like using this example. More people die on Mount Everest coming down Mount Everest than they do climbing Mount Everest. And I don't know if they're tired. I don't know if it's just, what causes that. But retirement kind of goes that way. We're taught how to save. We're not taught how to spend. So when we get to retirement, we have to be ready to reallocate your assets. Reallocate your assets to spend them down, or be able to create income out of an illiquid asset. So think about it as you go along, what does that look like? And even go back to this long-term care questionnaire. If you're in long-term care, one of the questions I will pose to clients as we're talking that through, if you don't have long-term care insurance, or if that's not part of your plan, tell me what assets you want to spend in what order to pay those bills. Now, I'll get a lot of responses. It's like, well, I don't want to spend those assets. Well, to have long-term care, that costs money. To live in retirement, if you're not bringing in a salary, it costs money. So we've got to reposition those assets to income so that we have the access that we need. Let's make sure we're spending those in the right order. And where that really comes into play, I will work with clients that have what I'll call legacy assets. I have an asset. Let's just for ease, let's say it's a cabin. That's the family cabin. That's where your kids grew up on their vacations. That's where you've taken your grandkids on vacation. Do you want to sell that cabin in retirement? Well, the answer that I find in a lot of these, everybody's saying, "Oh, no, no, I want that cabin to continue in the family." Okay, if that's not an asset that we can use in retirement or use for long-term care, what other assets are we going to spend first? So now think about this. If you're not in a position to make those decisions, mentally, you don't have the mental capacity to make those decisions. You either have a trustee or you have an agent under a power of attorney making those decisions for you. In that case, does your fiduciary, and anytime I use the word fiduciary, just think about the people that you've named and put in control of your affairs. So if your fiduciary has an option, do I sell the cabin or do I sell the house and use, I need cash. Which one do I sell? Well, if you're living in the house and that's where you want to be for your retirement years or your long-term care years, what asset do you think the fiduciary is going to sell? He's going to sell the cabin. And I've had clients that adamantly want that legacy asset to pass through to the family. They want it to stay in the family. Why? Because that's where the memories were. That's where they came together as a family and created all those wonderful memories. Well, if you haven't communicated that to your fiduciary, they don't know what your wishes are. So part of this is as you go through and plan for your retirement years and long-term care, we want to make sure we're spending the assets down that makes sense. We're spending the assets down in the order that you want to. Now, there's ways we can make up for that with, long-term care or annuities with long-term care attached to it, life insurance with long-term care attached to it. There's other tools. And these are tools that we can always talk about and bring those out if it ever makes sense. But we need to step back and say, what do you want to have happen and paint that picture? Because that picture has to match what the documents say. And then we have to make sure your people, the people that you're putting in charge, know what your wishes are. And so it becomes a big, think about putting that puzzle together. Think about you open up that box with all the puzzle pieces. If I looked at that, if you dumped it on the table and said, okay, Rick, now you come into the room and put the puzzle together. What's the first thing I need to look at? I need to look at that box. I need to look at the picture on the box. What is this puzzle supposed to be? Without that box and that picture, yeah, I can eventually put the puzzle together. But trust me, I'm going to be frustrated. And more than likely, I'm going to throw some pieces on the floor just out of frustration. Think about that. If you haven't told your fiduciaries, those people that are going to be in control for you and help you, if you haven't told them what your wishes are and how you want things to proceed, it's like working without the picture of the puzzle. They might get it right, but more than likely, they're going to do what they think is right for them, not what they think is right for you. And those may be two completely different things. So this is where we the planning is key because the planning revolves around you. And that's the steps we want to start taking. So as we go through, now start looking at this. you start putting your plan together. So I've been going through these things in the order that we need to go. First step was identifying all of your assets, identifying your assets, identifying how they're owned, because that's part of the picture that we start with. And that's going to drive us where, part of the planning, and we've talked about this, I most of the time the planning is going to involve a revocable living trust with a will that just puts things into the trust if we miss some on the transfers. You're going to have power of attorney for property, a power of attorney for healthcare to go along with your health directive. Now, with those documents, part of that is driven by your assets and how you own them. So it's one where if you ask me, do I need a trust? I may default, if I have to give you a default answer, I'd say most likely yes. But I've had clients with significant wealth that don't need a trust because the way they've held their assets, it's easy to transfer because we can transfer even without probate. Now, that's part of the picture. Now we go to the next part, and that's really what's important today, is making sure we start putting that picture together of how do we get from today to the day we pass away. And that's, for some, that's a long period of time. For others, it's not as long. But I don't care how long it is, we've got to paint that picture first, because we want to make sure planning is not just about giving your stuff away. Planning is not just about avoiding taxes. Planning is, number one, taking care of you now till the day you pass away. We want to make sure that we take whatever phase you're in, and we plan for it, knowing that, okay, we might have, today you might be working, running a business, whatever. Next phase is retirement. Next phase is long-term care. After that, then we're going to talk about distribution and making sure that works. So think about how that picture looks. What is it that you want to do? Are you going to spend more? Are you going to travel more? What I tend to find is most people's spending habits don't change significantly in retirement versus when they're alive, been working, because those habits are so ingrained, even though we talk about, well, we're going to do more. And I do have some clients that never traveled during their working years, retired and traveled a bunch. That was always their plan. They actually followed through on it. Most don't. But think about how you want to paint that picture so everybody understands. Then we organize the assets, and we organize all of those things to start matching that plan. So first is your assets. Next is your lifetime goals. What are you trying to accomplish? What do you want to accomplish? We align all of that, and then we start talking about distribution. And when we get into the distribution, we're going to have all the conversations about taxes. We're going to have discussions on probate. And so all of that is coming in more detail. And we'll talk about other additional planning that may have to happen so you can achieve the goals you're after. So it is a step-by-step process. It is one, I've done this enough. To me, it's just common, it's just natural progression, but we want to make that simple for everybody else to understand as we go through as well. So I've been talking a lot, John. Do we have some questions?
We have a question. We just have one question so far. We're waiting for more, but this will be a good time to jump into this. I think it's a very good question. I'm still not understanding how to even find an estate lawyer to work with. Great question. Do they need to be in my own state, which is the state of Washington State? What would be the price range? What questions might I ask when interviewing a lawyer to determine if he or she is a good lawyer? Great question.
Great question. And yes, you definitely want an attorney that is working in your state. And here's the reason why. Each state's a little bit different. Now I can group them. You know, and Washington is a community property state. So if I make the assumption that we have spouses here, community property is assumed any assets acquired during marriage are 50-50, that they're owned jointly, that it doesn't matter whose name's on it. It is assumed that it's owned 50-50 as community property. Now, that creates some great estate planning opportunities, let's put it that way. Because at death, and just so you understand it, you know, estate tax, the current estate tax is, as of January 1, is going to be a base of 15 million per spouse, and that's going to increase based on inflation. So we've got a very high federal estate tax. And so that eliminates over 90% are not going to have any worry about federal estate tax. However, you have to, and this is why you want to have an attorney that understands how to work in your state. So Washington State is community property. Washington State has a separate estate tax that kicks in at a little over $2 million. So if you have a home, qualified plans, it's fairly easy for a lot of people to hit that $2 million mark. You know, I work with a lot of farmers in Washington State, and they don't think they have an estate tax problem, but they do because of the value of their land. Versus if you cross the border into Oregon, Oregon is a separate property state. A separate property state means when you pass, the assets in your name are your assets. So if you know, married, and if I put the house and my business and my cars and all of our investments in my name and nothing in Kim's name, I have a probate problem. I may have a state tax problem in Oregon, because I know Oregon has an estate tax that starts at about $1 million. And Kim, my wife, if she passed away, she didn't have any assets in her name, no estate tax in the state of Oregon, and possibly no probate. So having somebody that understands your state laws on top of federal law will create a much better plan. I work with people in Louisiana as well, and Louisiana is not like any other state, and it is one where if an attorney is outside of the state of Louisiana, I won't even talk to him about a Louisiana will or trust or anything. I will only talk to Louisiana attorneys because it is so much different than the other 49 states. So you want to make sure that you, number one, somebody that is familiar and works in that state. Now, they don't have to live in that state, just so you know. They could be licensed in that state, but not living in that state. So we just want to make sure, number one, they're licensed there. Number two, that they have the ability to practice there. I like to ask for referrals. So I work with a network of attorneys out there, and I can go to every state and find somebody that I can work with. The questions I tend to ask are, do they do estate planning? And is that their primary business? Now, I can tell you this, I just met with an attorney in Phoenix who tells everybody that he's an estate planner. Well, I asked him, I said, how much estate planning do you do? And he said, well, actually were personal injury attorneys, but during COVID, we couldn't go to court, so we started putting ourselves out as estate planners to pay the bills. So I took a big marker and scratched his name off the list. Nice guy, and if I ever get in a car accident, I would call him, but I would never have him do the estate plan. I want somebody that actually does this for a living and understands what to do and why. So it is making sure that it is done and up to speed. So having somebody in the state, if you don't know, I mean, if your friends, ask around. If they don't have a referral for you, ask, and we can help you find somebody.
That's really helpful. I just remind people that they can ask questions on any aspect of estate planning, not just on the topic that you're talking about right now. So this is helpful. Got another question. Rick, can you define what assets are? A house, a car, a bank account, retirement accounts, jewelry. What else?
Think about anything that you own. So assets, I mean, and I understand this. Assets is a very, very broad category. So if you think about when we talk assets, it's anything that you own or control. So it's easy if you think about real estate, your house, if you have a cabin, if you have just a vacant lot next to your home that you own, or a building for your business. Real estate is a broad category. Now think of any of your bank and investment accounts. And that might be, when I say bank and investments, your bank account, your stock accounts, your retirement accounts, your life insurance, your annuities, anything that's financial. And what I'm really concerned there is when I look at any of those two, the financial and any of the real estate, I'm always going to ask the question, how is it owned? Who are the owners and how is it owned? Because that matters. I was on a call. This is one of the clients I help with in California, and it was one we were asking the question because they have multiple trusts, and they, some because dad had passed away years ago, some was in irrevocable trust, some in revocable trust. And we were asking and found out, well, yeah, mom had another bank account just in her name. And she made the comment, she said, well, there's not that much in there. That doesn't matter. The value, the amount isn't the big issue. It's, do you own it? Is there a title to it, and do you own it? Now, when we get to personal assets, think about all those things that you own that don't have a title to it. So it might be jewelry. It might be clothes. It might be, I grew up in Idaho, so it's guns. And and even like I deal with a lot of farmers, they have tractors that have no title to them. There's no license. And it's interesting that, people forget. Well, that tractor may not have a title to it. It may not be licensed. That tractor may be worth $250,000. I mean, they're not cheap anymore. And that's why, you'll see a lot of farmers driving some old equipment out there because it still works. So when you start thinking about assets, what do you own and what do you control? And we want to account for all of those things, because anything that you own or control that has a title to it is subject to probate. And there again, those are the things that, think about this, if you're not here today, what do you have that needs to be passed on to somebody else? And we want to do that to the people that you want in the most efficient manner that we can. And a lot of this, I will say this, there's two types of assets when I look at it. There's the legacy. Those are the heirlooms. And we want to account for those, making sure they go to the right people. And there's easy ways to do that. So I find that, where's mom's wedding ring? Who should that go to? And if you think about it, these are things that the kids fight about too. It's what, there again, like I said, I grew up in Idaho. So, everybody's who got dad's guns, for hunting or whatever else, because those are what the memories were built on. And those things we want to account for. Now, if you think about it, clothes, for the most part, we don't care. But I have dealt with, families that, they wanted mom's clothes divided up a certain way. And even, I've had some that have fought over that and never talked to anybody again. So think about what you have and identify it. Big assets are easy to identify, but you've got to start thinking through the small things, especially anything of value, so it's accounted for. And I've come in, I've handled estates where mom and dad are gone. There's were no kids close or no kids. And we had to come in and account for all of the assets. And did we find everything? Let's be realistic, probably not. We found everything we had a document to. But there again, you buy things that don't have titles, that don't have documentation. You knew it. It was important to you, but if you're not there, will we find it? So assets, anything that you can think of, we want to write it down and have it accounted for.
Great points. Next up, my husband is 74 and I'm 66. Neither of us have long-term care insurance. Is this a concern that I should be addressed, that should be addressed before any estate planning is undertaken?
I think it's one. Yes, it needs to be addressed. I almost think this is chicken and the egg, which should be done first. I hate to say both, but it's one, probably which one is more concerning to you, which one's going to keep you awake at night worrying about it. Long-term care, it is one where long-term care, the longer I'm in this business, the bigger of an issue that has become, because it's such a drain on the estate. And what I find is, and here's the big problem I come across. If you think about what assets do most people have in retirement? It's their qualified retirement accounts. It's that 401k they built up over the years. It's their IRAs that they built up over the years. And now they've got that plan. That's going to be our income in retirement. Well, now think about this. Most people, and there again, I deal with a lot of people that don't think about income taxes. Anytime you take money out of that retirement account, unless it's a Roth IRA, you are going to pay withdraw the money, pay the tax, and you get to spend the net amount. Well, now somebody goes into long-term care. And when they go into long-term care, that bill gets paid first, because we need mom or dad taken care of. We are going to pay that bill. So we're going to take more money out of the retirement account, pay more in income tax to make sure we have that net amount to pay for the long-term care bills. Think about what we've done now, and I'll use this individual that just asked the question. You've got somebody that's 74. I think the other age was 66.
Correct.
We've got an 8-year gap, and statistically 74 passes away before 66. And with that gap, if 74 uses up all those retirement assets for long-term care, what's left for the surviving spouse, or the well, in most cases, the well spouse. So it needs to be addressed. And I'm not saying you have to buy long-term care insurance. I'm just saying it's probably something worth looking at, making a decision to say, does this make sense for you? And there again, if you've got assets that can account for it, great. There again, look at it and see if it makes sense for you. But is one more important than the other? I think they both have equal weight to them.
We can provide a contact, as we know, Jim Maher, who has been helpful to us with, Medicare and long-term care insurance. So if the questioner wants to email me, we can make sure that we can connect you with Jim at McGrew and Maher. So happy to answer that question. This is a question that came in related to IRA. It says, are IRA assets owned individually, even if you live in a community property state?
Yes. And it's one I just had to explain this to somebody up in Washington State last week. It is one, any qualified accounts, IRAs, 401ks, all of those types of accounts, they are owned individually. The primary beneficiary will be the spouse. And so if you're in a community property state, you cannot transfer your IRA without your spouse's permission. So it's one, every transfer document in a community property state, yes, it's owned individually, but it's going to require the surviving or the spouse to sign off on the transfer or change of that account. So any qualified accounts, they're owned individually. We name a beneficiary. And typically what I will say, spouse will be primary beneficiary. I would say, I like to go to the trust as the contingent beneficiary, or the kids if they're old enough and we're going to give them, the estate anyway. So you've got to be careful there and how you handle that. But yes, they are individual assets, no matter what.
Next question. Rick, how long typically does this process take when, say, for instance, someone was just starting today to do their IRA, their estate planning? They have an IRA probably, but their estate planning, if we started, say it's okay, December 1st, how long would it take until you think that there would be a complete plan that someone would feel comfortable with in terms of going through the process?
I would say on the fast side of this, if you are prepared, it can be as short as 2 weeks. And part of that is, with all the clients I've worked with over the years, I've had clients come in, they already had everything written down, knew what they were doing, knew what they wanted to do. Let me put it that way. Knew what they wanted to do, had their asset list in place, and we were able to get the documents done within that 2-week period. Now, if you're doing a trust, and I will throw a lot of the attorneys under the bus here, because the big part of this is it's not just getting the documents done. So if you're doing a revocable trust, and this is something we're going to hit on even harder here over the next few sessions. If you're doing a revocable living trust, the big part of this is get the trust done. Now you have to transfer all of those titles to the trust. So your house needs to be deeded into the trust. Your bank accounts need to be transferred into the trust. All of these things have to come together and have the right title on it, or you end up in probate. So there's a lot of what I'll call trust mills out there. People will go to those and get their trust done. And the attorney in that case will slide a little piece of paper in there that says, by the way, I told you to make sure you transferred all of your assets into the trust or you're going to end up in probate. And he's going to have that documented in his file that I told you. Well, I told you and having something that works are two different things. And let me give you a worst case scenario. This was years ago. I had a new client in Oregon. They had just done a lot of planning. And part of that was it involved life insurance to make sure that they could pay off all of the debts of their business. If something happened to mom and dad, that business had to have, in their case, it had to have $8 million of life insurance to cover all the outstanding bills for the kids and the taxes and make sure it was be in place. They had just gone through all that planning, and the life insurance was supposed to be in an irrevocable trust. And when I went in to meet with them, they were not happy because they had just gone through all that. But a friend of mine I was with, and wanted me to talk to them, just make sure there was no holes in their plan. And they gave me 30 minutes. And I said, well, can I see your life insurance statement? And they said, sure, here it is. And I said, well, let me tell you the bad news here. This is not in your trust. And because you're going to have to pay estate taxes, that $8 million would only be worth $4 million to your kids in the estate. It would not do what you wanted it to do. And he asked me how I knew. And I said, well, the name on the top of the statement is your name. If it was in the trust, the name at the top of the statement would be the trust name. And we went back and forth over the next 30 minutes. He called his attorney, he called his financial advisor, and he called his CPA. And he asked me, he said, what does it take to fix it? And I said, we can transfer it in, but because we're working with federal estate tax laws now, if you die within 3 years, it's still subject to estate taxes. So he had to start from scratch on something he had just finished to make sure he didn't have to wait 3 years for that to be effective. He fired his attorney, fired his CPA, and fired his financial planner that day because they said, we promised you a result that would not work. So as you go through this, just make sure that you follow it through. So the documents, and this is a long-winded answer to that question, the documents can be done typically within that 2-week period. The next big part of that is it'll probably take, again, it could be as short as a week, could be as long as 6 months to make sure all of the assets get transferred into that trust to make sure it's bulletproof. And that's what we want to do. We want to make sure it's all correct, everything's done. That way, if something happens, we don't have to worry about probate. We're not in front of a court to get to the same spot we can get to with just a little bit of work. And I've done it a lot faster, but I can tell you some of the transfers, depends on what state you're in. Some of those, moving bank accounts, easy. Moving investment accounts, easy. Sometimes moving the real estate just takes we get a time lag on certain states and certain counties. And that'll drag us back a little bit. But we can work through that fairly quick as long as we have a client that's motivated.
Great. Those are all the questions. We don't have any more questions. If anybody in the audience watching has a question, you can continue on, Rick, or we can make another decision. But if you...
I think the big, these are good questions because I think a lot of people go into the estate planning process, one, not understanding what the process is.
Exactly.
And so it's anytime you're doing something that is new, something, especially in the legal world, it gets troubling. And so to control the cost, I think there was a question, what does it cost to do this? It's going to depend on where you're at and which states. Some states get a little bit more expensive. But if you're organized, I can tell you the price comes down. You know, if I had to ballpark most of the planning, it's going to probably be somewhere between I would give it a broad range, maybe 2 to 5,000. Could be a little bit less, could be a little bit more based on complexity. But it's one where the more organized you are, the more efficient you are, the more you've got your goals and objectives laid out. I can tell you most of the time with what I do is spending time trying to pull that out of a prospective client. What do you have? What do you own? And what are your goals? I mean, I have had clients in the past that have been referred to me that said, okay, I'm supposed to do an estate plan. Okay, what do you want to do? I don't care. And one client I remember, I mean, we went round and round and round. He honestly didn't care what happened. And I said, well, we're going to shake hands and part company because I care less than you do. If you don't care what happens, I can't make you care. And so it's pulling those goals and objectives out is a big part of the process. What do you want to have happen? So the more organized you are, and that's what this, going through the 6-part series is making sure you get things organized in a way you're ready to take that next step, and that next step is not going to be a mystery.
I do have a more. I think that's spot on. I've got a few more questions here. I guess I'll save that one for the end. Can you discuss the process of planning for the retirement phase of estate planning that you discussed earlier?
So the retirement phase, think about where you're at. I mean, let's build up to that phase of life. It prior to retirement, you've been building and you've been saving, and all of it is to get to that point of retirement. Prior to that point, if somebody passed away, we've got mechanisms in place. A lot of times I'll say that's life insurance is a big pre-retirement to help the surviving spouse and kids, to be taken care of. Now we hit retirement. Typically, we don't have, we're not responsible for paying for our kids and all that. So it's about you. And we want to look at that now and start saying from the retirement phase, if you're there, let's assume you are healthy, you have your mental capacity to make all the decisions that you want. The decisions you're going to be making, it's not as much estate planning in that part of it as it is a reposition of your assets to income. And we're doing that assets to income in the most income tax efficient way we can. Now, part of through retirement, if you get to the point you can't manage your affairs, or you just say, you want, one of your kids or somebody else to step in and help. This is where the estate planning part of it, either with a successor trustee, with a joint trustee, letting them step in and be part of that planning and helping take care of you in the retirement phase. So it's 2-part, but the big part is we don't want to get to that part of retirement and we don't have somebody in place that knows what your wishes are, how you want to be taken care of. And, there again, it's recreating the accident that's already happened. We want to plan before the accident.
Precisely. Having a plan. Here's a question. I'm assuming it says, has the OBBA, is that one big beautiful bill, I guess,
Yep.
or something, changed to state work? I'm not sure what OBBA is. I think that's what they mean. The
One
legislation
big,
that was passed.
Yep. what it did is it took a lot of the previous tax law and made some of it permanent. So what it has helped us do for the larger estates, it's given us more certainty in the estate tax. And let me back up to what we were a few years ago. So January 1, the estate exemption goes to $15 million indexed for inflation.
Mhm.
Now, let me tell you, when I started into estate planning, the estate exemption was $675,000 fixed. And so if you think about where that would be, everybody would be subject to the estate tax. I mean, I had clients that owned a home that was over the amount of the estate exemption. And so all of the planning was not just, hey, let's plan for you, your family, and those things. We have to plan for how do we avoid the estate tax, or how do we pay the estate tax. So the One Big Beautiful Bill did make that permanent. Now, how permanent is it? Well, it's permanent until there's a change in probably the House, the Senate, and the White House. So if that changes at some point to Democrat control, we probably will see a change in the exemption, which we thought we were going to see a couple of years ago.
Right.
Some of the other things that has changed is how where we're doing more retirement planning, where we're prepaying income tax in a low income tax rate environment, so that as we access it in retirement, we're doing it more tax-free dollars. So that's a couple things that the One Big Beautiful Bill has allowed, is more planning on the income tax side. And I would say for most people, it didn't really affect them on the federal estate tax side.
Okay. Next up, how do I take title if I own 1/4 of the real estate in a trust? How do I update the trust?
So I'm gonna have to make a couple assumptions here. So if they are the beneficiary of an existing trust, so and I'll
That's,
take it two ways.
that's the
So
way I understand it. Yeah.
if you are the beneficiary of a trust, you think about this. Picture a spigot. The spigot that the water comes out of the side of the house. If you're a beneficiary of the trust, you've got your hands under the spigot. Whatever comes out, you get. Until it comes out, you have no control over it. So that is a beneficiary. They have zero control over the trust. As the grantor of the trust, the grantor, so in this case, let's just put mom and dad are the grantors of the trust. They're the ones that decide what are the terms of the trust. What is this trust trying to accomplish? They're the ones making all those decisions, how we want things divided, how we want it managed. And now they draft the trust. The trustee's job is to manage the trust based on whatever the trust language is. And let me reiterate that. A lot of times I will see that the trustee is giving very, very black and white guideline, directions. Thou shalt do this and nothing else. If it's that black and white, and you come in and say, well, can't you distribute more money? The answer is no. Because if they do, they're violating their fiduciary duties. So I saw this early in my career. It was there, a lady had come into our office. After the fact, I found out we were the fifth law firm she had approached. And she was the beneficiary of a trust. It's a family name I can't say because everybody would know the name. And that trust, grandpa had set it up years before with a thou shalt only make these kind of distributions. And that money was in there. She wanted to spend it. And the trustee said, I like you. would love to give you more, but this is all it allows me to do. That's it, period. Or the trustee can have flexibility to do anything in their discretion. And if they have discretion, they can distribute it all to one person to the exclusion of everybody else if that's what they decide to do. So if you're just the beneficiary, you have no control over that quarter interest until it's distributed to you. If you are a trustee or grantor of that trust, you've got to look and see what provisions does it allow you to change or amend. And then that property, as long as it's in trust, is you can't change your quarter interest until it's removed from the trust. So I think I answered that question. If I didn't, we just need a follow-up question to it.
I think that might cover it. Can any items that do not have, you mentioned earlier about titles and ownership, can any items that do not have titles or ownership documents be put into a trust, like guns that you mentioned, coin collections, collectibles, that sort of thing?
Yes. So when we transfer them in, we'll use a general assignment. And that general assignment transfers it from your name to the trust. I also like this because those are, if you think about gun collections can have a significant value, even though there's no title. We know coin collections, stamp collections, all of those things that don't have a title, they may have a significant value attached to them. We want to know what they are. So we do a general assignment with a very good description of what they are. So there again, like if it's coin collection and it's a significant collection, we'll identify it and then move them in. I have even gone to the point on some assets like that where we've taken pictures and attached the pictures to the general assignment. Think about this. You're no longer there. And will anybody know that those exist? And we just want to make sure that
Exactly.
everybody knows.
Perfect. Here's a fun one. Is there special concerns on an expensive airplane worth seven or more figures?
Yes, with airplanes, there's a whole different set of things that we have to do there. Typically with an airplane, I will not have that in a revocable living trust. I will separate that airplane away from all the other assets and typically set that up. I like using a Wyoming LLC to own the airplane. Your revocable trust can own the Wyoming LLC, but I want that plane segregated away from everything else purely because of its liability. And then we also have to look at on the plane, is that being leased out? Or is it purely just being used for pleasure? And so there again, it's going to bring in some different rules on what we need to do there. But yes, we definitely want to segregate that asset away from everything else so that it's more of a liability protection than an additional estate planning issue. And then we would have over the umbrella over all of that planning would be the revocable living trust. So
Smart.
2 or 3 extra steps there, and part of it is understanding the use of that airplane will be a big key.
Smart.
Yeah.
That's great. Next question. My house mortgage will be paid off in 2031. My car loan in 2028. Do I have to wait until those are paid before I can work on a revocable trust?
No, we want to do that now. What I will tell you, especially on the house, most mortgage companies will allow you to move that house into a revocable living trust, but we want to make sure we ask for permission before the transfer happens. We're not getting out. They know they still have the mortgage lien against the house. That lien stays in place, and we move it into the trust. That way it's there for estate planning purposes. But with today's, with especially, and I get very, cautious here because a lot of people have very low interest rates from refinancing, and so we don't want to trigger any acceleration clause. I do see a lot of people transfer the home, don't tell the mortgage company, and 90% of the time, 99% of the time, the mortgage company wouldn't care anyway. As long as you keep paying the bill, they know they're in first position and it's not affecting them. But in today's environment, if you've got especially one of those refinanced rates, we just want to let them know ahead of time just to make sure we don't trigger an acceleration clause. With your car, same thing, but it's one most cars we don't worry about because you can transfer it into the trust. That's the asset probably least concerned about, unless it's I treat that as an asset, just a normal get around car. But same thing, you don't have to wait to pay it off.
Perfect. Two more questions. What to do if you are overwhelmed by stuff, as in assets, as well as financial stuff? It's a lot of stuff.
Organ
We all know the feeling of being overwhelmed.
trying to get it organized, especially organized into categories.
Mhm.
And it's one where I work with clients that I see their asset list and it's extensive. And most of that is get it organized into categories, and then we can work, then we work through how to address each one of those. Sometimes it's best in trust. Sometimes we'll use something like an LLC to hold assets, but it's getting it organized will be the key to getting through that layer of frustration.
Great. This is our last question. I don't see any other questions here. I guess there's one more after this one. So, what's our next task or homework when we resume in January?
The next task will be working through, we're going to introduce some of the additional concepts so that, we've talked about the trust and will. Now we want to talk about some of the more advanced topics, just to be aware that they're there. Doesn't mean that you're going to need them, but I find that having the education of, do you know that they're there? So it'll be an introduction to those topics. And, I'll give you an example, special needs trust. If you're working with special needs children, there are things that have to happen that go well beyond the typical revocable trust. They're, again, not overly complicated, because once you talk it through, it makes sense. But those are things that we look at. If you have an operating business, how do we factor that in? Are you worried about asset protection issues? Different states, have different, asset protection, issues, and people that own, especially like rental real estate. Are they worried about, those assets, being taken in a lawsuit? So we're going to next time we're going to talk about more of those issues. So prior to that, the homework will be just reviewing some of those topics.
Great. So here's our last question. We're now after the top of the hour. If a revocable trust is not the best option, most assets are in your retirement accounts. Can a car title have a beneficiary?
Car title cannot have a beneficiary, but it is one where you can put, a lot of titles, like, I realize only half our cars, half of them have my name on them, have mine and my wife's name on them. So we can put a second name onto that title just understand if it's one of your kids and they get into financial trouble, you could lose your car. But that's one in most states. If we have all of the other assets taken care of, in most states, you're allowed to do basically a small estate transfer where we can transfer a limited amount of assets by basically by a sworn affidavit. So it depends on each state. And let's say your car's worth $25,000 and you're in the state of California. We can transfer that with a small estate affidavit where we just say, you swear you're going, whoever's managing your estate will sign a sworn document saying the assets that are subject to probate are less than, and we'll put in the state amount. The value of the assets in the estate, or in this case, 25,000, that's the value of the car. It's going to go to the named person that's in the estate, and you'll sign it and notarize it. And then every state has that provision in there. So if we've done everything else and that's all that's left, it's an easy fix. So I did that, on my mother-in-law's, her husband passed. We had taken care of everything. We found out he had one little thing left that we just didn't know about. And so we, signed this affidavit, done.
Smart. That's perfect. That's great.
Yeah.
Well, that was the last question. Rick, we thank you for another clear and practical session. And thank you all for your thoughtful questions and participation today. We truly hope you're finding these working sessions useful. If you've registered for the series, you will automatically receive links to all session replays. Now, given how full December tends to be with holiday activities, as you know, we will not be meeting next month. Our fourth session will be on Tuesday, January 21st at 4 p.m. Pacific. And before we go, we warmly invite you to join us for our online Christmas celebration on Sunday, December 7th at 2 p.m. Pacific. You'll enjoy both returning and new musicians, an inspiring Christmas message, and yes, our annual Ardenwood staff lip sync. This program is our gift to you. Let's usher in the Christmas season together, and you can register at ardenwood.org. Wishing each of you a joyful and blessed Thanksgiving. And until next time, goodbye for now.